Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Keep me seated. Oh my God, like you have any private attorneys? I don't even see him. Oh, there you are. Okay, come on up.
Judge, I was sitting with my attorney, and you probably couldn't see me. Yeah, I'm ready.
All right.
Judge, I was sitting back with my attorney, and you probably couldn't see me.
No, I couldn't. Oh, all right. Yeah. Mr. Buster Berry was blocking you. What we got?
Your Honor, this matter has been before the court before circumstances from our perspective had not been fully made available to the court. And I had told the state attorney that this was not what we would call full-blown evidentiary motion with respect to bond, but there are two case numbers before the court. Just wanted to make this presentation to the court for the court's consideration. Mr. Mann is before the court on two case numbers, and in those matters, there is no bond at this time. The nature of the allegations in the first case, Your Honor, I would point out, is a strained would be a calm word to use, domestic scenario, and his wife is present in court today, and I've spoken with her, and I think she would agree with my assessment that it's a strained relationship which led to conduct which has brought Mr. Mann before this court. Your Honor, as the court is well aware, the purpose of a bond is twofold. A, for the protection of society, and B, to ensure that a defendant comes to court as the court would direct the defendant to do. Your Honor, I would point out as follows, that there had been a bond in place because of a subsequent act. That bond was revoked, and there is no bond at this time. We would suggest as follows, that Mr. Mann, whose parents are here, Dr. and Mrs. Mann are present. They've come down from the state of Missouri to be with us today, and they are in court. We would suggest as follows, that Mr. Mann, if the court were to follow the suggestion that I'm going to make, would be in a position that A, he's not going to miss court. He's very invested in, and his parents are very invested in, the aggressive defense of this case. Secondly, the no contact that is essential, we believe, in this matter, and the state certainly agrees that that's an essential factor, would be best served by him being in the state of Missouri and the court ordering that he live with his parents in the state of Missouri with a monitor. We would suggest a signature bond in the amount of $100,000 that he and his father could sign. It would do the two things that bonds are designed to do in our belief, Your Honor: protect the public and ensure he comes to court. He's going to stay in touch with us. His parents have done so, and we believe that although this matter had been considered, that the point of emphasis had not been made with respect to his ability to stay in Missouri on a monitor with his parents and have no contact with the victim, who is present today, and I've talked to her. She, of course, doesn't agree with our position, but she's present, and we've had a respectful conversation about that. So that's what we're seeking to do, Your Honor.
Ms. Glisson?
Your Honor, the state's position is the same as it was when we had previous bond hearing for this case on May 25th of 2023. The victim was also present. She objects to a bond. If there's been no change in circumstance, Your Honor, none. So the court's already, Your Honor has already denied the bond hearing on this case. There's been no change in circumstances. If the court wishes for me to go more in depth like I did in the last bond hearing, I certainly will. But for time, I'm not going to unless the court's considering giving a bond, considering there's no change.
Judge, we're not asking, we're asking for a bond. We're not asking there be a bond. We're asking the court to do just that. We're just asking for a large signature bond with safeguards that make sense, and they frankly do.
Well, I see under two separate case numbers, violation of pretrial release conditions, and it looks like he had some type of pretrial, he was released on some type of bond or something and allegedly violated it.
Same victim. Same victim in two cases.
We agree that there are allegations, Your Honor, that we're defending.
The victim is here.
Yes, sir.
And, well, I'm going to deny the motion for bond at this time based on the allegations of already violating pretrial release conditions.
Your Honor, I understand very well. Thank you, sir.
Thank you.
Your Honor, that's all I have. Good day, sir.
Mr. Stewart?
Good morning, Your Honor. May I please the court, Your Honor, Brad Stewart, on behalf of James Lee Jr., Judge. He's an inmate.
He's out of custody?
He's incarcerated, I know. He has no bond.
Okay.
Yeah, Judge, I'll pass that.
James Bernard Lee?
Yes, sir.
Here, but no, we'll find out.
Okay.
Between us, we'll get it all. We'll figure it out. If she's doing it. That's good. I'll just watch as much. Me too, right?
Visit this matter with James Lee Jr., Judge.
Okay.
We're on for VOP status. He does have a new law violation at 23 CF 2055. I'm simply asking to track the VOP with the new law violation. I believe it is set for December 27th.
Is there any objection to that?
No objection.
Okay, that'd be fine.
Very good, Judge. That's all I have. May I be excused?
Yes.
Thank you, Your Honor.
Morning, Miss Coffey.
Your Honor, I believe the case was set for status.
Okay.
I think at the last hearing, the state was to provide some additional discovery. I still haven't received it yet. However, Your Honor, what I did propose to the state is there were two motions that I agreed to continue in order to get this discovery. So one is set on Thursday. One is motion for cost for the purposes of an expert. So I would like to expedite that motion. So we're going to hear that on Thursday.
Okay.
The second motion was a motion to dismiss, and I believe that one's going to be set for November 2nd, because it's going to take some subpoenas and so forth, just so we can move the case along, Your Honor. So that's where we are as far as the status, and I'm still waiting on the discovery.
Well, was there any objection on that cost request?
Judge, we would just note that this is a traveler case. As far as expert witnesses, she said she's a forensic expert, but the lab at OCSO has been going a re-download using Gray Key, which is some new technology they didn't have at the time of the case. So hopefully, with that information, she won't need her expert. She'll be able to open the BDR disks. We're not aware of anyone else who needs to be deposed at this point in regards to the services she would need. But again, we know this is up to discretion of the court.
Were your expert, the costs you were wanting, was that for expert witness?
Yes, Your Honor.
Do you have any idea how much?
I don't, Your Honor, but I can get that.
I think we have some guidelines as to
Sure.
the amount. I'm inclined to grant that, so you don't have to come over. You were just going to come over Thursday for that?
Sure. Yes, Your Honor.
I mean, it's not on the docket, but why make you come over? So I'm inclined to grant that, but check out whatever costs you're running, because I don't want to approve something and then it's not. You retain someone, and then you find out you can't really pay them all that. I mean, find out exactly what amount hourly rate.
We'll definitely stay within those guidelines, Your Honor.
Okay. So I'll just send me an order, run it by Ms. Barrickman, and, okay. All right, thank you. All right, Ms. Flowers. Oh, come on up.
Good morning, Your Honor.
Morning.
Joseph Mitkevichus for the record on behalf of Carlos Javier Rodriguez.
All right.
And there's a waiver on file, Your Honor.
Okay.
That's case number 23 CF 894. The case was set for today for Mr. Rodriguez to enter a plea. I wanted him to review with an immigration attorney prior to accepting that plea. He's currently in Texas. I still think it's his intention to enter that plea, but he did not, wasn't able, didn't get done what I asked him to. And so the state has agreed to leave their offer open until October 30th. If we could set it on October 30th, I have told my client that he must come over from Texas on that day and either accept the plea or we will set the case for trial, I suppose. I believe he will be accepting the plea offer on the 30th of October.
No objection.
All right, October 30th, and I have to issue a no bond capias if he doesn't show up.
I've
And
informed
that
him.
probably won't help him on his immigration, so.
No, I have informed him that that will happen if he's not
Okay.
here on the 30th.
All right, thank you.
Thank you very much, Your Honor. I have nothing
How
further.
about sending an order?
What's
Sending
that?
an order,
Send in an order?
sending me an order saying it's continued to October 30th. and he's-
You'd like my office to send you an order?
Yeah, run it by the state.
Okay, sounds good. I'll have them do that.
Simple order, so we have something in the record.
Okay, sounds good. Thank you very much, Your Honor.
Run it through the portal to my secretary. Ms. Merrifield? Or Mr. Hardy? Mr. Hardy?
Of course she's ready. Sarah. And then so Mr. Snipes, it looks like. Next with you.
Good morning, Your Honor. We're here, this is Shane Phil, and we're here today. I filed a motion for leave of the court to redepose the alleged victims in this case. The facts are stated in the motion, but I'll briefly recite them that Mr. Fell was represented by the Office of the Public Defender back in October of 2021. I don't know if the dates are correct. I'm trying to pull up the motion. But during the time that the depositions were taken, they were taken by an assistant public defender that Mr. Fell had had serious issues with prior to the depositions and had filed a Nelson motion. The assistant public defender went through with the depositions, and I do have copies of those. I have transcripts of they're not on video, they're just recorded depositions. I'm requesting, I've been on Mr. Fell's case now for a little over a year, and we're preparing for trial. These are he's charged with 2 capital felonies and 2 other felonies punishable by life. The only evidence that I'm aware of that will be put on at trial is the testimony of the 2 alleged victims, who are now both over the age of 18. And I'm requesting the court grant me the ability to speak with them, to depose them, to assess the case so that I can advise my client on whether any plea offers are what he should accept or whether this should go to trial. There are questions left unanswered. There are the fact that the original depositions were not videoed, even though I think the alleged victims, I don't know if they were under 16 at the time, and I don't know the circumstances of why the original depositions weren't on video, but I'm just unable to properly advise him on issues of credibility, issues of the victim's testimony being what it's going to come across as, and I'm just not properly able to advise him without the ability to at least speak with these alleged victims before trial. So I'm asking that the court grant me the ability to do that.
State.
That there was the initial interview, the CPT, and the depositions that have already been done of these victims to relive. We do understand Ms. Flowers' position. However, we would request that she provide a list of questions and guidelines of what have not been previously asked. The parties agreed to otherwise. Before those depositions, certainly if she has follow-up based on that, then that would be fine. But we would ask that she not be able to go through everything that has been previously discussed in prior depositions and prior CPT in the initial interview questions.
Well, the alleged victims are adults. Is that legal adults?
This was a case that came about in 2020, however, it was several years after the incident. They were under the age of 12 at the time of the incident.
I know,
They
but
were
now.
young teenagers, or they were young teenagers, and now they are about 19.
Okay.
19 and 20.
Since the seriousness of what he's facing, I'm going to allow you to depose them. And
Thank you, Your
since
Honor.
you are, well, if you had initially taken the depositions, probably no.
Of
But there's
course.
a different attorney, so I'll allow it.
Thank you, Your Honor.
Okay. Send an order, okay, please?
Yes, Your Honor. Thank you.
And Judge, just to be clear, that wouldn't include ask questions of any nature that have been previously asked.
Ms. Flowers is, I'm not going to, I mean, if she wants to, she's not going to waste their time or intimidate them or anything, but if she wants to ask, I'm not going to limit that because if some other lawyer asked a question and the victim answered it, and Ms. Flowers wants a little bit more information, some explanations, what they meant or something. She wasn't there to see what they were talking about, perhaps. So I'm not going to limit, but you're not going to get out of hand or anything. I know
No, Your Honor,
that,
I will,
you know, so I'm
that is not the purpose of this.
I'm not going to put a
but I-
restriction on Ms. Flowers.
Thank you, Your Honor.
Okay.
And we would note for the record that the previous depositions, Mr. Russell was also present in addition to APD,
All right.
Olivia Ramsey, so.
Okay. So that's.
Thank you, Your Honor. I'll
granted.
prepare an order and
Okay.
send it. Thank you. I'll come see you.
Thank you.
Your Honor, this is Allison Snipes, 23 CF 1824. We've reached an agreement with the state, and we've previously gone over it.
All right.
She's just quickly signing it, and all the other parties have signed. You have Rich?
All right, State of Florida versus Allison Ann Snipes, 23 CF 1824. You're Allison Snipes. Would you please raise your right hand to be sworn? You swear the testimony you give for us course of truth, so help you God.
Yes, sir.
All right, you want to enter a no contendory plea, a no contest plea to burglary of an unoccupied conveyance, threat against public servant, and resisting officer without violence, two third-degree felonies, and a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under?
No,
Yes.
they did not.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 3, you're judged guilty, sentenced to time served. On count 1 and 2, you're judged guilty, sentenced to 18 months standard probation concurrent. Between count 1 and 2, take the anti-theft class, mental health evaluation, and complete any recommended treatment. No return to the scene. No contact with the victim. Reserve on restitution for 90 days. $415 court cost, $100 cost of prosecution, $150 cost of defense.
May I approach the score sheet, Your Honor?
Yes. Anything further?
No, Your Honor. Thank you.
Okay, thank you.
And
Thank you.
supervision fees waived, Your Honor?
Yes.
Thank you.
And that's all I have today, Your Honor, maybe excuse. Thank you.
Okay,
I'm ready, Judge.
all right.
Good morning, Your Honor.
Morning.
Brady Merrifield on behalf of Philip Perez, 23 CF 1227. Mr. Perez is present. And Judge, we've reached an agreement, if I may approach.
All right. All right, you're Philip Allen Perez Jr.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes.
This is State of Florida versus Philip Allen Perez Jr., 23 CF 1227. Let's see. All right, you want to enter a no contest plea, the charge of criminal mischief, is that correct?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of all the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No,
Are
sir.
you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Merrifield's done for you on your case? Your attorney?
Oh, yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. You are to enter a 12-month pretrial diversionary with the following conditions: complete a substance abuse evaluation and any recommended treatment, abstain from possession or consumption of alcohol or any controlled substance without a valid doctor's prescription. Prescription must be provided to probation when requested. Attend at least one AA meeting per week for the first 6 months of the agreement. Complete all mental health evaluation, any recommended treatment, and any medication is prescribed. Have no violent contact with Julian Pamela Perez. Don't go to 616 Lighthouse Church Road, Holt, Florida. Possess no weapons. Pay $150 cost of prosecution, pay any court costs, fees, fines assessed by the court, pay $857.68 restitution to Julia and Pamela Perez. Cost of supervision is waived. Diversion will be supervised on mail-in status. If you complete it within 12 months, the state's apparently agreed to dismiss the charges, correct?
That's correct, Your Honor.
All right, well, get it done, and I guess the charges will be dismissed.
I'm sorry, sir, I didn't.
He said.
Get it done.
Yes, sir.
Thank you, Judge. That's all I have this morning.
And Your Honor, we have the PTO agreement. We'll send him to the office and get it signed and turn around and e-file it back with the clerk.
All right. All right, Mr. Hardy.
Morning, Your Honor. First case I have is Timothy Holt. Hey.
All right, Timothy Holt.
Your Honor, Mr. Holt's being held on a $60,000 bond, and we filed a motion to reduce that bond. He's currently charged with trafficking 14 grams or over and possession of controlled substance. At $60,000, Mr. Holt can't possibly make that bond. We'd ask the court to at least cut that in half.
What does the state say?
Judge, in this particular case, there was a search warrant that was executed on his residence, and the package had 1,021 grams that were field tested for positive for suspected meth. And post-Miranda, defendant admitted he knew it was approximately 2 pounds of meth. 400 grams or more is a life felony, and 200 grams or more is a 15-year min-man sentence. In addition, there were 3.5 grams of heroin that were found within his body. He does have a history of drug offenses. In 2020 CF 2185 and 20 CF 2020-20. He was placed on probation, possession of controlled substance, and a lesser included for trafficking in heroin to sell, manufacture, deliver. He also has 17 CF 3564 and 17 CF 2078, which were both possession of controlled substance cases. Given the large amount of drugs that were found when the search warrant was executed on his home and the other drugs that were found within his body, we believe that the cash professional bond of $60,000 is more than appropriate.
Just facing some minimum mandatories, Mr. Hardy.
Yes, Your Honor.
I'm going to leave the bond the way it is. Thank you.
Thank you, Your Honor. Your Honor, I also have Philip Merritt. I want to pass that for just a moment, speak with him
All right.
again.
Okay, call them.
First one would be Ms. Kennedy.
Who? What's the first name?
Shakisha.
Shakisha Kennedy. Was she noticed to be here? She got, Miss Anna, she got noticed.
Your Honor, the state would ask for no bond capias if Ms. Kennedy did receive notice.
All right, no bond capias.
Thank you, Your Honor.
All right, good morning, Mr. Hutchinson. You're here on a violation of probation. Is there any type of offer for Mr. Hutchinson? Apparently, he doesn't have an attorney.
Your Honor,
Hang on one second, hang on.
I'm sorry, Your Honor, Mr. Hutchinson's basis for the violation is a new failure to register, so a new felony charge that's still currently pending.
Well, let me appoint an attorney to represent you, okay?
Sir, I was aware that Mr. J. Williams was my attorney. My significant other went and talked to him Thursday or Friday of last week.
Judge, I think we may have represented him in the past. I don't know if the court has appointed him, us to him on this matter.
Is there some conflict or something?
No, Judge, I'm still with the Public Defender's Office.
Oh, you, so
Or it
there's
may have
no...
been on another case number. But the
Well,
court
let me,
wants to appoint
I'm
us.
appointing the public defender to represent you, okay?
Yes, sir. But if I may, can I address the court, sir?
Yeah, if you,
Okay, I have this charge of failure to register. This was from...
hang on one second. Don't say nothing that the state, Ms. Basso here,
Sir, it doesn't matter. I mean, it's in the computer. It's in the computer.
yeah, but I don't want you to say something.
I just want to let the court know, this was from July, and I did not fail to register. I registered late because they had no deputy. The lady retired.
All right, well, Mr. Williams and his investigator will check it out. That may go a long way in helping you, I don't know, but please don't say anything else, because Ms. Basso will use it against you.
Okay,
And Your Honor,
please, can I finish, sir? Please, it's just, my family's about to be evicted. I'm the only source of income. I have a no bond and I have a $10,000 bond. If I don't get home, they get kicked out. I have no other income, no other way to help my kids and my old lady keep their home. I just want to ask, I will wear an ankle monitor. I'll do anything the court asks me to do. Just please allow me to go home and go back to work. I have to at least try to keep my family in a home.
Your Honor, Mr. Hutchison is a violent felony offender of special concern, therefore he would not be eligible for a bond at this time based upon his violation. What we can do, we'll ask this track with the new law violation, which is set for 1026 arraignment, and perhaps if Mr. Williams has some input on his behalf, maybe we can move it up.
Judge, basically, he can get a bond, but the court has to have a safety of the community hearing first, which is essentially a more detailed bond hearing.
Well, Why don't you attorneys talk about and see if you can come up with something to let him out on, some type of bond? If you can, good. If not, then we'll have a hearing.
Be quiet for
on
just a
it.
second,
Is there a court date that's possibly, like I said, the arraignment is set for 10/26 on the new case, which is 23/2042.
If
You want
I,
to move it up sooner than that and see if we can,
well, actually, what I was going to see is if you had some time this morning for you and I to kind of step out and see if there's something we could agree on, at least in terms of bond conditions, and maybe go ahead and hear him again this afternoon. Are you
right.
going to be here at 1:30?
oh, yes.
Okay.
Bring him back this
Bring him
morning.
back for 1:30.
Let's do that, Judge, and we'll see if we can work something out
All
for
right,
Mr. Hutchison.
we'll try to work it out for you.
Sir.
Okay.
I'll leave it out then.
And the public defender's appointed.
Thank you, Your Honor.
You're appointed, public
Yes, sir.
defender's appointed.
And Judge, just for the court's information, we represented Mr. Moore in the past as well.
All right, this is Zaki Moore. All right, he is here, Mr. Moore is here on a violation of probation. Is this a VOP arraignment?
It is, Your Honor.
Mr. Moore, the state has filed a affidavit, or probation's filed an affidavit alleging you violated probation. Is there any type of offer for him, or do we need to go ahead and appoint public defender?
Not at this time, Your Honor.
I'll appoint a public defender to help you, represent you, see what they can do, get your case resolved for you, okay?
Okay.
Thank you.
Judge, at this time, I'll just enter a denial for him, and if we can reset him for the next date without subpoenas.
Okay,
I'll see if I can get
that's,
something worked out for you.
what date would that be on a VOP? October 26th?
Judge, I have no idea. I always defer to the clerk on that.
October 26th.
Thank you.
Okay, hopefully they get it resolved for you. Okay. All right, Ms. Rivers.
Your Honor, I do have one that's out of custody. He's not on the docket for today. He's on the docket for 10/26. He thought it was for 9/26, and so he is here a month early. His name is Dwayne Seals, 23 CF 1662. Mr. Seals, if you want to come forward. We have resolved this matter, Your Honor. The state was unaware because this was set for a month from now. If I may
Okay.
approach.
And Your Honor, this will be one where I have to follow up with the score sheet since
All
it's on
right.
the docket, but I will get that filed.
All right, well, this one's not on a docket, but Mr. Seals is here. Usually I get it the other way around. It's, they're supposed to be here today, they don't show up for a month until they end up in jail, then they realize that, whatever. But you're Dwayne Seals?
Yes, sir.
All right, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
Okay, this is 23 CF 1662, State of Florida versus Dwayne W. Seals. Mr. Seals, you want to enter a no contest plea to the charge of failure to report to a sheriff's office.
Vehicle registration.
Vehicle registration. This is a third-degree felony. You understand that? You want to enter a no contest plea to that?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentences you to time served in the county jail, $415 court costs, $100 cost of prosecution, $150 PD fee. I'll give you how much time you need to pay those things? 6 months?
Anytime, sir.
180 days to pay it.
Yeah.
And, okay, thank you so much.
Thank you.
Thank you.
Have a good day. Are you ready for any of mine? Your Honor, while he's doing that, I have another one that is on the docket, which is Stacy Lynn Wilkerson. That's going to be 21 CF 847. I did it for a status. I set it for status, Your Honor. That'd be number 28, page 12.
Okay.
Your Honor, she is currently in the Florida Women's Reception Center in Ocala. She has been filing motions with the court pro se. Her motions have been stricken, and the court informed her that she had the public defender's office. She has reached out to me and has requested that I go forward on her case. So before I have my sit-down phone conference with her, she is asking the court to allow her to appear from prison via Zoom. So I was just wanting to get feedback from the court on that. She is also asking if she can plea from prison to a concurrent sentence. She was a PTI failure, and she...
We'll have to do an order to transport. We can't do that Zoom stuff for prison.
And is the court agreeable to an order to transport?
If we're going to get her case resolved, I guess so.
Then I will submit that order. Thank you, Your Honor. And the rest of mine are in custody.
Judge, we've got the bond situation with Mr. Hutchison resolved. We can recall him this morning if he's still here.
Okay.
Harris?
Your Honor, we've reached an agreement in this matter. However, there were some things that had to be verified, so he has not been able to sign the agreement, and I'm going to ask him to sign it at this time.
Okay.
So, verify that it was all paid.
Cool.
And if I may approach, Your Honor? I do apologize, I had to handle it.
All right, you are Timothy Lee Parrish.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
This is 16 CF 958, State of Florida versus Timothy Lee Parrish. You want to admit that you violated probation, is that correct, sir?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you
No,
from
sir.
knowing what you're doing here today? Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it, will reinstate and extend.
By 12 months.
Your Honor, if I may, I think the deal was extend 1 year from his original termination date, which was
Oh, I got you.
September the 19th, 18th, I'm sorry. So we're going 1 year from there.
All right, extend 1 year, 12 months from the termination date. Complete previous ordered classes, GPS at $1 per day. Waive cost of supervision, $100 cost of prosecution, $150 PD fee, and adjudicated guilty.
And Your Honor, the state has agreed that as an incentive that she will allow him to terminate early upon completion of all the conditions.
That's
that
correct, Your
right?
Honor. And we do wish him to finish those classes in a timely manner, and so we believe that'll give him an incentive. Additionally, Your Honor, I believe it's standard that we ask the GPS monitor be affixed before he's released from the county jail.
Okay. You can terminate early and have a GPS before release. Thank you.
Your Honor, Charles Gregory, State Probation. If you can put the word "shall" in front of that, shall terminate, then when his 1 year's over, we don't have to come back to court to tell you, to ask you, can he get off? We understand it, but the department has a problem understanding.
I wrote it real big. I put stars by it.
Thank you.
How about that? Okay.
Uh-huh. You gotta go, you gotta.
All right, next.
Your Honor, the next one is Christopher James Stearns. He's number 26 on the docket. Your Honor, I was able to work out an agreement for him. I have gone over what it is with him. However, he does need to sign it. If I may approach.
Are you Christopher James Stearns?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
This is 22 CF 3069, State of Florida versus Christopher James Stearns. You want to admit that you violated probation, is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it, reinstates probation, converts the remainder of probation to community control with same terms and conditions, waive cost of supervision, $100 cost of prosecution, $150 PD fee. Anything else?
No, Your Honor.
Thank you.
Go see them. Your Honor, the next one is Jordan Stetson, number 27 on the docket. Yeah, well, this is the last one I got anyway.
Okay.
Your Honor, we're before the court on his case, again, 23 CF 1971. In this particular case, he is alleged to have committed aggravated battery and tampering. And in this case, the alleged victim is his wife. The events were alleged to have occurred inside, outside the home, and they have a video security recording system. The victim, according to the police report, provided some video footage. The footage directly, but it was very limited in what she provided. And Mr. Stetson is requesting video footage of immediately prior and immediately after. So we sought out to try to get that video footage. The name of the company is Vinvent, and we contacted them through our investigator, talked to them about a subpoena to produce the video footage. And the reason for the request for a subpoena was going to be because the video system, the bill is in her name, not his name, their husband and wife. Vinvent said that they would not honor a subpoena, but if the court were to enter an order saying that they are to turn over the video footage from that evening, that they would provide it.
State? Okay, send me an order.
Thank you, Your Honor.
Mr. Gibbs?
I have some inmates, Judge. And I just need to write up a written for an out-of-custody client.
Coming up? Okay. This is Mr. James Henry Banks, 23 CF 1081, 23 CF 1083, 23 CF 1554. Judge, we got a, my mind completely blank there. We had an evaluation by a doctor judge that recommended that he be found not competent to proceed. Judge Schlechter already signed an order for 3 cases that were in mental health court for Mr. Banks. So we're asking to admit that report if the courts receive that and have Mr. Banks committed to the state hospital for competency restoration.
State.
Your Honor, the state has no objection to the court considering that report, and we concur in that recommendation that he be committed to Florida State Hospital for restoration.
All right. And Judge Schlecter's already entered a similar order, is that correct? Okay,
Correct,
send me an order, thank you.
Thank you, Judge. Your Honor, this is Mr. Beetler. We had set him for a status today to see if we were able to resolve the case. We're still in negotiations with the state and still need to look into the case some more. This is a new law with 2 VOPs attached to it. Judge, I'd like to set him for October 30th for pretrial and see if we can work it out by then.
State has no objection to that, Your Honor.
Okay, October 30th, thank you, sir.
Thank you, Judge. Your Honor, Tim gives on behalf of Mr. Kelvin Brown. This is 22 CF 1420, 22 CF 1823. Judge, we are also trying to get him some referrals to treatment options. I'd like to put him for October 26th. We should definitely have it by then.
There's no
As
objection to that.
whatever treatment options we can get for him.
October
That should get you by then.
26th, thank you.
Your Honor, Tim gives on behalf of Ms. Tierra Demby. This is 23 CF 27, 23 CF 277, 23 CF 606, 23 CF 828, 19 CF 1483. Judge, she has just returned recently from the Florida State Hospital. The hospital is recommending that she be found competent. I have no objection to admitting that report and the court taking that report for its own findings. We're also looking into some mental health treatment options with Ms. Demby and ways to try to resolve this case. If the court does find her competent, I would request to put her for October 30th for pretrial. That way we can have any referrals in that we need to try to resolve Ms. Demby's cases.
Your Honor, the state has no objection to the court considering the recommendation to find her competent, and the state asks that that be done. And we have no objection to setting that for the 10:30 docket.
All right, go ahead and send me an order, and I'll have a chance to look at it. Thank you.
Thank you, Judge.
We'll set it for 10:30.
And I'll send you an order to find her competent, Judge.
Thank you.
See you as soon as he can. Your Honor, Tim Gibbs on behalf of Akeem Dixon. This is 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, 22 CF 1506. Judge, we're here for a Nelson hearing. I had received service from the clerk that Mr. Dixon had sent a Nelson hearing motion request on September 6th. And so the court may need to swear him in so we can hear from Mr. Dixon.
Mr. Dixon, please raise your right hand and be sworn. You swear the testimony you give for is course of truth, so help you God? All right, tell me what you have, what problem you have with Mr. Gibbs. You feel that he's being ineffective.
Just the communicating and telling, I have not heard from Mr. Gibbs. I've been locked up going on 4 months now. I've reached out to him several times. We've been trying to get hold of Mr. Gibbs as well. My mom just passed on Sunday, and I've been trying to get a hold of him. We've been calling, we've been leaving messages. I've even wrote him literally last month, and I've been writing him the whole time about just possibilities with my case of trying to go to another program or trying to get out to handle the situation before my mom passed, but she's already passed now. And now I'm trying to deal with that because it's just me and my sister. My mom just passed Sunday, and my wife and kids found her. So now I'm trying to find out how to deal with that and try to get home to handle with that situation. But I just haven't had no communication. It's one thing, he comes and tells me one thing that we can do, and then when we get to court, it's something totally different. In the last court session, whenever you put us on recess, I even brought him a statute about the time mandatory that's credit. I came in here with no new charges, and he did not look at it. He did not do anything about it. He just told me nothing changed and then continued me for 2 more months when I was trying to get that resolved so I can would have been able to hopefully be home with my mother before she passed. But now she has passed this Sunday, and now that is my concern of trying to handle that. And I'll take whatever I can to go home so I can pay my respect to lay my mother down.
Mr. Gibbs?
So, Your Honor, these are all VOPs, indeed, allegations stemming from that he was in Teen Challenge, allegations that he left without permission. I've been speaking with the state to try to resolve it. The last offer that we got was for 36 months DOC with credit for all time served, or 24 months DOC with credit for only the VOP time that he has, which is maybe about 10 or 11 months total. So it would, or 2 months total as far as just VOPs, closer to 3 or 4 months now. The state does want him to relinquish prior credit, and that's, I think, one of the issues that we were speaking about earlier, because yes, he is entitled to his credit, but the state can, of course, make an offer where he would relinquish credit, and he doesn't want to accept that. I've been asking the state about potentially doing things like drug court or other programs. I have asked the state recently about Jada House. They have said no, Ms. Leone is not here, but Ms. Leone declined that offer, that counter offer. The score sheet that we do have, assuming that it's accurate, shows that he scores approximately 60 months. So the state's not willing to budge on that.
60 or 16?
60.
60, and you've got him potential offers at
Yes.
30
So
months?
yes, Your Honor. And so I've met with him at least, let's see here, 4 times in the jail since he's been in jail. He's been in jail most recently since the end of June on these violations, Judge. I'm trying to go back to his motion as well to address anything else that may have been in there. So we're at a situation, Judge, where we haven't been able to resolve it with the state. He, of course, can plea however he wants to plea. The state can offer whatever they want to offer. They don't have to accept anything. So it's
Well, it
a tough
sounds like,
situation, but
Mr. Dixon, sounds like he's making rather substantial efforts to try to get your case resolved with reasonable offers, and, you know, from what I've heard, perhaps you can get up there, Mr. Gibbs, and go over it in more detail, but he's not ineffective, and he's making every effort he can. Right now, the prosecutor handling your case is out of the country on a medical emergency, so that offers makes it a little bit difficult, but if you get it resolved, and it sounds like he's got good potential deals for you, get half time and plus all of this credit for time served. I don't know how much credit for time served has he got. Do you know?
the estimate that I have, Judge, is if he were to get all of his time, there's, I believe, over a year's worth of credit.
I got 14.
Yes.
14 months?
Of worth of credit from just including the newest case.
I mean, you're looking at not hardly any time. I mean, you know, you get all that. It sounds like he's making good progress on keeping you out of prison, is what I'm trying to say, or very, very little prison instead of 60 months. So I find that he's not ineffective and continue working on his case.
We were
Yes, sir.
otherwise, Judge, set for an evidentiary hearing with subpoenas on October 26th. Okay. And Judge, he now wants to request a furlough for his mother. I don't have any details on that beyond the fact that his mother's passed this Sunday. I don't know if the court wants to consider that.
I'll take a GPS monitor, whatever I need to do. I just need to show my respect to my mother, please.
What does the state say? I don't usually grant it with, well,
They would object, Your Honor.
yeah, I mean, I'm sorry. I get furlough requests every week from people whose parents or brother or sister is sick or passed, and I just can't, if the state won't agree, I don't allow it. If the state agrees, I do. The state says they disagree.
Well, I want y'all to agree for me to have a furlough. Bury
Any
my mother.
violations of probation do you have?
This is, I believe this is the, well, I don't know which violation this is, but there are 6 case numbers.
Been on since 18. I'm asking to have a furlough to go bury my mother with a GPS monitor.
State objects, Your Honor.
Well, if the state agrees, I allow it. If they object, if anyone objects, then I don't. So hopefully we can get your case resolved. Thank you.
Judge, I believe he's already set for October 26th for an evidentiary hearing.
We'll move it up if we can get it resolved.
Certainly.
Is that for 2 o'clock?
Yes.
Thank you.
What are you trying to do, Joe?
I've already asked.
30-month sentence, half your sentence is already served.
She's sticking to that. She's not willing to.
Your Honor, if I pleaded out to you, what would you be looking at?
I don't know. I don't have enough information to give you a fair sentence at this time. But I don't know. I'd have to hear from the state and the defense, but I know that, when you walk in the door, don't they knock off 20% of your sentence right then and there?
So when you get to DOC, Judge, my understanding is that with the 85%, once you walk in the door, your 85% starts there. So if a person has 10 months to serve in DOC after whatever time credit they have, they'll end up serving 8.5 after they get to DOC.
I don't know about the information. I don't have enough information to give you a fair sentence. So talk to Mr. Gibbs and maybe we'll move you up and see what happens. Thank you.
Your Honor, I've got Philip Merritt,
Philip Merritt, okay.
21 CF 3302, 21 CF 3494, and 22 CF 2724. At this time, Mr. Merritt's going to withdraw his previously entered plea of not guilty and enter a plea of no contest in case 22 CF 2724 as charged. The other 2 cases, both 21 cases, will be no prost. The sentence would be 12 months community control, followed by 24 months probation, a substance abuse evaluation and treatment, no alcohol or controlled substances without a prescription, no return to Precision Tactical, restitution of $1,469.93 to Precision Tactical, and $515 fines and court costs.
You, Philip Merritt?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
This is 21 CF 3302, 21 CF 3494, 22 CF 2724. You want to enter a no contest plea
22 case, Your Honor.
in 22 CF 2724 to, let's see, where is that? What is the charge on that?
Your Honor, it's at the bottom. I ran out of room.
Oh, okay. All right, so you want to enter a no contest plea to grand theft, less than $5,000, a third-degree felony.
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Anyone force you, threaten you to enter this plea?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? You aware of your rights you're waiving?
Yes.
Is anyone, are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Hardy's done for you on your case?
Yes, sir.
The state's going to dismiss 21 CF 3302 and 21 CF 3494.
That's correct, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicates you guilty. Sentence you to 12 months community control, followed by 24 months probation. Have a substance abuse evaluation and treatment. No alcohol or controlled substance without prescription. No return to Precision Tactical, and restitution of $1,469.93 to Precision Tactical, and $515 fine and court costs. Adjudicated guilty.
All right, I'd also ask if we could waive the cost of supervision while he's on probation.
All right, I'll do that.
Thank you, Your Honor.
All right, thank you.
Your Honor, if you would like, I got in touch with Shakisha Kennedy, and she is here.
All right.
And I think we can resolve it today. She brought in some paperwork.
Okay, we'll recall the capias. Is she represented? No.
It was her motion, Your Honor. I think the violation was failure to pay court costs and failure to complete substance abuse treatment. She brought me in proof that she has since completed the substance abuse treatment, and we would request that she be allowed to terminate with the outstanding monetary obligations to collections.
Your Honor, with the confirmation that she has completed the treatment, the state would have no objection to the defense or to probation's recommendation.
All right, we'll do that.
She had to leave work to get here. She still
Okay.
got the fryer on that KFC.
Yeah.
Still
I do,
what?
Literally.
Still doing what?
They made me RGM, and now I run my own store.
Oh, well, good.
Yes,
All
sir.
right, well, good. So you're off probation now, okay?
And outstanding costs to collections if there's anything
Yeah,
left.
outstanding cost of collections.
Thank you, Your Honor.
Thank you.
Have a great
Good luck, ma'am.
Thank you. Mr. Williams, do you have any cases that you want to do?
Judge, everybody that I have is incarcerated, but I can go ahead and start calling those cases if they're ready.
All right. Well, wait a second then.
Mr. Gibbs may be done in just a second.
Why don't we take a 15-minute break?
Yes, sir.
How about that?
Okay. Mr. Standard.
May not need to.
All right.
Your Honor, Tim Gibbs on behalf of Bradley Standard. This is 21 CF 3108. We have reached an agreement with the state, if I may approach.
Okay. All right, you're Bradley Standard?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for this court's the truth, so help you God? This is 21 CF 3108, State of Florida versus Bradley Standard. You want to enter a no contest plea to, is it leaving scene of crash involving death? Is that correct?
That is the charge, Judge.
A first-degree felony?
It is, Judge.
Minimum mandatory 4 years. You understand that, sir? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. We need to hear from any victims or anything, or?
Yes, Your Honor. Mary Grimes is here to give a victim impact
Okay.
statement pursuant to Marcy's Law, and we will provide a score sheet to the court. I believe he scores 22.8 months,
Something like that.
but there is that 4-year minimum mandate.
And this is Miss Grimes, and Miss Grimes, you're aware of this sentence, this plea, negotiated plea?
Yes, sir.
And you want to make a statement, which you're very welcome to do, entitled, and have every right to do, so I don't think I need to swear her in or anything, just go ahead.
Yes, sir. Mr. Standard, I'd like to let you know that on the day of the so-called accident, which I agree that it was an accident, that accident took my brother, who had 3 other sisters besides myself. He had 6 nieces and nephews, too many grandnieces and nephews to account for. He has a super-duper 2-year-old great grandniece and nephew. He has 2 sons. He has 2 great grandchildren that he'll never get to spend another day with. He was to come to my sister's house the next day to spend a surprise 26th wedding anniversary with her. Instead of doing that, I got the great honor of going to my sister's house to tell her, prior to all of the guests coming to her home, that her brother had tragically been killed in an accident. What a wonderful anniversary present that I got to give. And we all found out about it on Facebook. The accident occurred 1 mile from my daughter's house. My granddaughter come past the accident and didn't even know it was her uncle. She had no idea. She was stuck in traffic, not knowing that it was her uncle that had been laying on the road. We went out to the accident 2 days later, and everybody said, no, he didn't have a helmet on. He did. He was hit so hard by you in a semi-truck that his helmet was laying on the left side of the road. No, his head wasn't in it, but his helmet was on the left side of the road. Personal belongings that were on him were on the left side of the interstate, not the right, where everybody said it was. You claim you didn't know you hit him, but the motorcycle was standing straight up with the headlight on as you pulled off with your semi. The ironicness of the accident is my brother was a semi-truck driver also. He loved the highway. So while we hurt bad for our brother and no longer being able to see him and share all the memories that we have with him, you blessed us by his passing in the 2 ways that he loved the most, driving a semi and being on a motorcycle. All I can say to you is may God bless you in the rest of your life. Thank you, Judge.
Judge, Mr. Standard did want to request, if at all possible, that he report either later this week, but that I leave that up to the court.
The state would object to that, Your Honor. If the court sentences him today, the court loses jurisdiction.
The court is going to impose a 4-year Department of Corrections, minimum mandatory 4 years, credit for time served, court costs, $100 cost of prosecution, $150 PD fee to collections, reserve restitution for 90 days, adjudicated guilty. Thank you.
And is that in stanter, Judge?
Yes.
Thank
you. I need a score sheet, I think.
I think Ms. Sandler will send one to the court later
I'm
today.
emailing the score sheet to the court and Mr. Gibbs.
All right. Next.
Still have other inmates, Judge. I have Dufell next. Your Honor, Tim Gibbs on behalf of Hunter Dufell. This is 23 CF 825. Judge, we are still in negotiations with the state. Mr. Dufell would like an opportunity to fully review his discovery further before we try to resolve this case. I'd like to set this for October 30th for pretrial, and we can go from there.
Okay, any objection on that?
What's the defendant's name?
Dufell.
Dufell. Hunter?
No objection.
Okay, October 30th. Thank you, sir.
I'll get you that. I already sent that over.
How many clients do you have this morning?
Judge, I have, I believe, 4 more inmates.
All right, because we need to take a break here.
Very well. Your Honor, Tim Gibbs on behalf of Michael Duncan. Judge, I believe I was just appointed to his case. I know he has a new law up here. He has a new law in the south end, as well as, I believe, 3 total VOP cases. We're going to have to figure out which way everybody needs to transfer. I've already spoken with Ms. Leone about where cases need to go. I believe they're all going to have to go to the south end. I'll enter a denial for him today on this VOP, so the court has that, and we can go put a control date for next week, the 5th.
Okay, how about that?
Confirm which direction the cases need to go.
And Your Honor, Ms. Leone's notes do indicate that the transfer will be to Fort Walton Beach, but let's go ahead and leave it for a control date for next week, just to make sure everything goes through.
October 5th, then.
Thank you, Your Honor.
Yeah, we'll have to look at it. We'll come back next week if they stay up here, okay? Your Honor, Tim Gibbs on behalf of Clifton Edwards. This is, right here, Mr. Edwards. This is 16 CF 2384, 17 CF 313. Judge, these are violations of probation, I believe based on some new Louisiana charges. Speaking with Mr. Edwards, he would like to enter an admission to the bench this morning and proceed to sentencing this morning if the court would like to entertain that plea and sentencing hearing this morning on Mr. Edwards. I do not have a score sheet from the state. I do not know what he would exactly score. He's on probation for 2 third-degree felonies. He lives in Louisiana. He's from Louisiana. These are older case numbers. He wants to get back to Louisiana. He has pled to those cases in Louisiana and is on probation there, wants to get back to Louisiana as soon as possible.
Your Honor, this is also Ms. Leone's case. Obviously, we have no objection to the entry of a plea, but we would ask that the sentencing be set off so that we have an opportunity to review it and prepare the appropriate score sheet and an appropriate argument. As I said, it's Ms. Leone's case. We're not familiar with it, but we're certainly willing to handle it before she returns if we need to.
When do you think she'll be back?
Your Honor, if we could just set it off, we can go ahead and get it ready. We don't have to necessarily wait. We just can't do it today.
Want to bring you back October 5th?
That would be wonderful, Your Honor.
That's fine, Judge.
I mean, he needs to know exactly what the offer is or whatever it is, and the prosecutor needs to be here to argue, but I don't have any problem getting it done if that's what but October 5th, I don't want to take a plea.
Thank you, Judge. Since we will continue it, I'd like to withdraw that admission on his behalf, enter denial for the record, and then on the 5th.
I haven't accepted an admission.
Very well. Thank you, Judge.
And we'll get you a score sheet, Mr. Gibbs, and also an offer, and we'll take care of it one way or the other on the 5th.
That works.
Okay, thank you.
Your Honor, Tim Gibbs on behalf of Jeremy Ford. This is 22 CF 3188. Judge, this is a violation of probation. We'd like to enter denial on Mr. Ford's behalf. We actually did just file a sworn statement from one of the witnesses for this violation that we sent to the state, so I'll be needing to speak with Ms. Leone as much as possible to try to resolve it. I think we can do that next week, so I'd like to leave him on 10-5.
Okay, October 5th. Hopefully we can get it resolved.
Yeah.
Thank you.
Next week, next Thursday. Your Honor, Tim Gibbs on behalf of Elizabeth Graham. This is 22 CF 570, 20 CF 2264. Judge, we're working on getting her referred to other treatment options. I'd like to put her for October 26th. That should get us plenty of time to make sure any treatment options are available.
Okay, October 26th.
Thank you, Judge.
Thank you.
And I think that completes all of, the only other case that I have, Judge, is this afternoon, Michael Bullaboy. That's 21 CF 2621, 21 CF 2633. That's on the 1:30 docket. I've already spoken with Ms. Leone. We have agreed to continue that hearing to October 26th. Since she is out, it was set for an evidentiary hearing this afternoon.
Billabo?
Yes, Your Honor.
Yes, Your Honor, that was our request.
October 26th?
Thank you, Judge.
Okay.
We don't need him this afternoon. Thank you very much.
Well, Mr. Williams, how many cases do you have?
Judge, I've got Damon Hutchison to recall. We've reached an agreement on his bond. And then I've got 1, 2, 3, 4, total of 5 cases. We're going to and that includes one that was originally set for this afternoon. We're going to resolve this morning.
All right, we'll just go ahead and do it.
All right, Judge.
We'll go ahead and get these.
They are here for Gregory Geiger, who's not either one of you, and represented by Mr. Dees, Robert Dees.
You have an email? Okay. You want to continue it?
They're defendants or something?
Sorry?
Defendants?
The defendant is incarcerated.
He was supposed to have he was supposed to be here at 9 o'clock.
Y'all are here on behalf of the defendant? What's his name?
Gregory Geiger?
Geiger?
Yes, sir.
Judge, he has Mr. Robert Dees. He sent an email saying he's seeking to continue at this point, and he's running late from Santa Rosa County.
So he's on his way but running late?
Yes.
All right, well, he's apparently on his way, so hopefully your travel wasn't a waste of time, so.
What's your name, ma'am? Okay. Judge, this is Leslie Livingston. At this time, we don't have an officer to resolve the case. It's a violation of probation. I'd enter a denial on her behalf. It's here for a VOP arraignment. It's Ms. Bosov's
And it will be a
case.
DOC offer.
It's gonna be a what?
It's going to be a DOC offer, Your Honor. She does score out to the Department of Corrections, and
We'll put this, what day did you want, October 30th?
that'd be fine.
It's a
Your Honor.
VOP case, Judge, so,
October
That'd be
26th.
good.
all right, Judge.
Hopefully you can get it resolved October 26th, okay?
Yes, sir.
Thank you.
Judge, likewise with Patrick Medina, he has 2 VOP cases. I'd suggest that we set him for the 26th as well.
Any objection?
Done before that.
Can we?
Talk about it.
About October,
Recommendation, he just needs to get it.
Okay, all right.
want to bring it back this
if-
afternoon?
We can do that, Judge.
You can get it
We can do
resolved?
that.
Let's bring him back this afternoon.
We'll bring you back this afternoon.
Mr. Williams, do you have the DOC paperwork on that?
I believe,
Okay, whenever you get that, I'll show you the records.
I don't think I did when I went out to see him Friday, but,
Go ahead and take your next call. Make sure you have it.
Judge, this is Dusty Mobley. I met with Mr. Mobley. He's actually not on the VOP docket. He was set for a potential plea today. I spoke with him last Friday. He raised the possibility of a conflict of interest arising out of an older case where the conflict would be continuing. I did research that, and those facts do exist. I'm awaiting a decision by Mr. Russell, the office supervisor, on whether or not we're going to withdraw and try to get him RCC appointed.
Only bring him back October 5th.
All right, Judge.
Thank you.
Mr. Newell. Judge, on Mr. Newell's case, we're close, but we're not there yet. He's got a pending misdemeanor DUI and driving while license suspended that's the sole basis for the violation. That's coming into court on October 2nd, so I'd like to pass him again. We need to see what's going to happen with that. Now, in speaking with his attorney on that case, he does indicate he's got a triable case on the DUI, so the court may want to pass it until the 26th.
Go to the 26th. If it gets resolved, you can bring him up to the 5th.
Yes, sir. All right, I'll see you again then, okay? Judge, this is Mr. Hutchinson. I've spoken with the state. The state's willing to release him on bond with a GPS monitor and a reminder to report to OCSO registration unit as soon as you get out. You've got to register again when you get out of jail. Okay? What sort of cash bond or monetary bond do you think you can make?
I'm not able to make any bond until my bank account. I can't access my bank account. Out of jail.
All right, he's got a monitor.
Yes, sir, it would be a monetary, but he's indicating he's not able to hire a bondsman because he can't access his accounts.
What's he charged with?
It's a failure to register, Judge.
2,000 signature.
All right, thank you, Judge.
Sign yourself.
And, Your Honor, we'd ask the GPS be affixed prior to him being released from jail.
Okay, it's a signature bond. You just sign.
On both charges?
That would be on...
1,000 each.
1,000 each, okay. Yes, sir. It's sign out, then plus the monitor, and you will wind up paying for the monitor. There is a fee for that.
Your Honor, if I may, Mr. Hutchinson is on supervision with us right now. In lieu of going through pretrial, we will be the ones that's going to hook him up on our GPS.
That's fine.
And we request it at $1 a day.
That's okay.
Thank you, Judge.
Remain in
Right.
custody until we get out there.
All right. Y'all get this case worked out.
You want it now?
Okay. They're going to put it back on for you, okay? And you'll pay $1 a day for it. All right?
And I'm sorry, we originally discussed running it with the new law violation, so what day do we want to set that?
I think our new law violation's on for the 30th.
26, I believe, for the arraignment, is that correct?
That sounds right. I don't have that file in front of me. We weren't appointed on this
If
one
we
yet.
could run it, Your Honor, with 23-2042, which is a new law violation, for whatever day it's set, I believe it is the 10/26.
All right, and I'll appoint the public defender if you haven't been appointed.
Thank you.
Thank you, Judge.
I'll see if you can get this case worked out.
We will, Judge.
Okay, so you should be released today.
Sir.
Okay.
Thanks, Your Honor.
All right, Mr. Hutchinson. I'll come out and see you.
Don't tell anybody that I was kind-hearted. I don't want that getting around.
No, we'll keep it a well-guarded secret, Judge. All right, Judge, I've spoken with Ms. Lucky, I've spoken with the state. It looks like we have this matter resolved. I've gone over the rights with her now probably 5 or 6 times. Ma'am, if this is what you want to do, I need to get your signature right here. Judge, it's going to be a plea as charged. It's a DUI, Duval, third within 10, and a second offender, driving while license suspended. Ma'am, do you mind if I date this for you?
No, sir.
Okay. It'll be year county jail, well, 1129 county jail, followed by 4 years probation with DUI conditions.
4 years probation, that's
Didn't it say
not
4 years
minor.
probation?
24 months of community control, followed by 1 year of probation.
That was your original offer, 1 year county jail plus 2 years community control, followed by 4 years probation would be a sentence in excess of the statutory maximum. What we just talked about was 4 years probation.
That's not my agreement. I'm not going to agree to 4 years probation. 2 years of community control, followed by 1 year of probation. You want to pass this?
Bring it back October 5th.
Thank you, Judge. All right, ma'am. Judge, that's all the cases that I have
All
for
right,
today.
Mr. Geiger case will be at 1:30 today then. Okay, recess till 1:30.
All rise, please.